Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Morning, everybody, and welcome to the Appeals Court session for February 3rd, 2025. I heard from a reliable source that there will be 6 more weeks of winter. So your panel for today is I'm Greg Massing. To my right is Justice Rachel Hershfang. To my left is Justice Gloria Tan. We have 6 cases on for today, although the last one is going to be on Zoom because of a health issue for one of the lawyers. So I see experienced counsel here, but for anybody else in the room, 15 minutes per side, no rebuttal. We are very familiar with the briefs and the records, so no need to give us a long factual introduction. Just jump right into it. As I said, if you have 15 minutes, but there's no requirement that you take them all. There's no penalty for finishing early. And we all have these tablets in front of us which have the case materials. Don't worry, we are not looking at the news. We're looking at your case materials. So with those introductory remarks, the first case is Commonwealth versus Rivera, 23P1023. Attorney Sheketoff, good morning.
Good morning, Your Honors. Robert Sheketoff for Mr. Rivera. Today I want to address only the failure to give the lesser included offense instruction for assault and battery. There is a charge conference that addresses this issue. It's cited in the Commonwealth's brief, where the trial judge ruminates on this request, suggests that there may be a factual basis for it, and understands that it is the defendant's theory of the case in effect, and says that he will consider it, and then he makes the decision not to give it. That's not on the record. It's just he doesn't give it. And at the end of the charge, in a long laundry list of objections, the defense objects to the failure to give the lesser included offense instruction on assault and battery.
Attorney Sheketoff, can I just ask, I'm curious about that, because that's one of the questions I had in reading through this case, that they addressed the lesser included assault and battery on a Friday. I think it was like October 31st, right? They just closed the evidence, and they're having preliminary discussions about jury instructions. And he makes those statements that you say, in which he says, you know, there's certainly evidence that the jury could accept the theory that this was an intended beating, and that there's evidence of him punching, intended beating. That's certainly the defendant's entire theory. And he ends up saying that's assault and battery. And that's, I think, transcript 8, page 189, into page 190. And then he goes on to say he'll consider it, right? And then they break, and they talk about other jury instructions, and they come back Monday, November 3rd, and have a more formal charge conference. And they talk about all these other jury instructions, and their main focus was on, I think, the second degree, the jury verdict slips, and self-defense. And it never gets brought up again by anyone, including defense counsel, although she does preserve the objection afterward. So I'm sort of puzzled by the fact that he made statements, you know.
Yeah. So I wasn't trial counsel.
Right.
Trial counsel is actually an exceptionally good lawyer, and all she had to do was preserve her rights by objecting at the end of the charge, which she did. I, too, find it inexplicable that there wasn't a further discussion about this issue, but there wasn't. And my view is my rights are protected.
Of course, I'm not questioning that. It was just.
Yeah. This is what happens when you have busy trial lawyers, and there's a lot of issues you're raising, and sometimes you don't focus on your best issue for a second time with the court.
So the Commonwealth makes some interesting arguments, and one of them is that there was no that this idea of that the Commonwealth sort of that your client started it by planning this attack, created a situation where, knowing that the victim was going to be armed, created a situation where there was a plain and strong likelihood of death. They say the third prong malice is sort of necessarily there. How do you respond to that?
Okay, so I have two responses to that. First, it was not necessary to believe that the defendant knew that the victim was armed ahead of time when the planning was made. There is testimony to that effect from one of the two drug addicts who helped set up the meeting. The female testifies that she sent a text message to him, to the defendant, warning him that the victim was armed, and that he responded, "We're armed too." But that text message was never produced, and the jury's instructed to take her testimony with caution because of her cooperation agreement, and she gave a long statement, and this develops over time, this claim about the gun. It's not in her initial statement. There is some other evidence that he knew, and there's inferential evidence that he knew because there had been a robbery the time before, a week earlier, and on that occasion, it wasn't Mr. Butt who had the gun, but his co-venturer. The other evidence that he knew is my client's cousin, Anthony Santiago, said that he overheard a conversation in which my client told his father and an uncle that when he was recruiting them to go on this venture, that the victim might be armed. But that, too, is a cooperating witness who had motive to lie and who did not tell that story initially. That happened over time. And those of us that have done these debriefings notice a couple of things. One is people never tell the whole truth at the beginning. So it's conceivable, just because you didn't tell it at the beginning, you're telling the truth at the end. This is a common phenomenon. And we also know that people learn when they're being interrogated what the interrogator wants to hear in exchange for their cooperation. And so there are rational explanations for in both directions.
Can I ask you to follow up on that, Mr. Sheketoff, to draw maybe a finer point? I understand looking at the issue of whether this it was improper not to give this lesser included. We obviously view the evidence in the light most favorable. We indulge all inferences in favor of your client. So I think there are kind of two pieces to the gun knowledge. Did your defendant and his compatriots know that Butt had a gun? And then there's also, did they make a statement about themselves being armed? The second one, I think, is much more fragile because that comes only from Ms. Coleman, only in the later debriefing. There was a lot of cross about that. I can see pretty clearly a road, again, taking the facts as your client would have them, to ignoring that statement. But you've just articulated two different bases that underpin evidence that your client knew that he was going to a gunfight, essentially. Is it your contention, does our analysis have to disregard both of those in order to get where you would like us to go?
So my short answer to that would be no, because the defendant did not testify in this case, but I use this as an example. If a defendant testified that he knew that the victim was armed and that he knew his compatriots were armed, but he told his compatriots, under no circumstances, pull out a gun. All I want to do is beat this guy up. And that's what he did. He started a physical fight with the guy, and then one of his compatriots kills him. If the jury believed him, he would be entitled to an assault and battery instruction. And the evidence that my client knew that the victim was armed is from the cousin who had a motive to lie and only developed that story at the very end, from the drug addict who testified and had a motive to lie and claimed it was in a text message, which she was never able to produce, and from the general inference that if he had done a robbery with a compatriot who had a gun a week earlier, he might have a gun. So in closing argument, my trial lawyer said, these are her first words: "Ladies and gentlemen, Jose Rivera had no intent to kill Martin Butt. What he intended that day on September 9th, 2012, was to go and beat up Martin Butt. That was the plan, and that's what he planned on doing." This is her theory of defense, and I think, and I suggest that there is a basis for that theory of defense in the evidence, and the case law is very old on this. I
We
think
say hoary when we like it, not old, just it's
okay.
hoary.
It's
Yeah.
well, yes, I'm
That's a good thing.
experienced, not old, even though I know everyone hanging up on the wall. And that's true. I know everyone hanging up on the wall. In this old case called Myers, which is at 356 Mass 343, the SJC said, under that rule, there must be an instruction on assault and battery if, but only if, the evidence raises a reasonable doubt that the acts of the defendant did not cause the victim's death. And here we have that situation, in my view. So that's my argument. Unless there are any other questions, I will take advantage of your rule that I don't have to use it.
One more on this. How would you, so assume we agreed with you that the instructions should have been given, how would you explain the prejudice?
The basic theory of a lesser included offense instruction is that it promotes rational fact-finding. And that's why we've gone from letting the parties decide whether they wanted to gamble to saying the court actually has a sua sponte obligation to give instruction that is called for by the evidence. Because we don't want to put, the theory is we don't want to put juries in the position of knowing that this defendant did something that deserves punishment, but not being given the option to decide that that punishment is the lesser punishment of assault and battery, forcing them in effect to say that, well, if we're going to find him guilty of something, and his lawyer just confessed to us in closing argument that he is guilty of something, the less something we can find him guilty of, the least something we can find him guilty of is murder too. That's why if the case law has gone that if the jury had convicted him of murder in the first degree, I would not have an argument here. Because the theory is that they were given a lesser choice and they picked the higher choice. So the idea of the lesser included offense is to promote rational fact-finding. And supposedly that's good for everybody. Thank you.
One question? Okay. We'll hear from the Commonwealth.
Good morning. May it please the court, Catherine Jansen for the Commonwealth. I think here, the fact that the defendant punched the victim is a little bit of a red herring. I think that would be a separate assault and battery. He was charged as a joint venture for this murder, so he is liable for the acts of his joint venture if he shared the requisite intent and had some meaningful participation. So the punch, I would say, would be the meaningful participation. But I think you can find from the evidence in the light most favorable to the defendant is that he knew that the victim had a gun and that he had a gun even before he went into this confrontation, because he was presumably on the way, and I think that fair inference in light most favorable to the defendant is that he was already on the way to this confrontation when Coleman texted him and said that the victim had a gun, and he said, well, we have guns too. So it suggests...
But in light most, sorry, in light most favorable to the defendant, do we have to believe that?
I think when you're looking, I think you do when there's not contradictory evidence about that. Because if you look at whether or not we're going to be crediting stuff or not crediting stuff, then the jury could theoretically not credit anything in the Commonwealth's case, and then the defendant would always be entitled to a lesser included offense.
Right, but, I mean, I think there was very effective cross-examination of Ms. Coleman
Yes.
of the type that is done of a cooperating witness. And it is unquestionable that juries choose not to credit the testimony of cooperating witnesses, right? That's why prosecutors make sure that it's bolstered and that it's additive rather than standing alone. And this stood alone. There was nothing but Ms. Coleman's testimony, not even the alleged text messages that she said existed but couldn't produce. So I don't think it's not a situation where, you know, the jury, where it's a question of, well, the jury could discredit anything. The jury was explicitly invited by defense counsel to discredit this witness's testimony. And that does happen. So why is it not the light most favorable to the defendant for us to view the full record evidence as if the jury discredited Ms. Coleman, at least on this point?
Well, I understand Your Honor's point. However, when you're looking at the evidence, whether you're entitled to a lesser included, I think you need to look at what the evidence actually was. And I guess I wouldn't go as far to say it was uncontroverted for the reasons you stated, but this was the evidence, and there was no contradictory evidence to that fact.
Although, I mean, then there's, even if we do credit that testimony, Attorney Shektoff just argued that if his client had said, yes, be armed, but under no circumstances shoot him, and here the same witness, Coleman, says that she understood that it was just going to be a beating, not a shooting.
And that's, I think, different. That's her assumption and understanding about what the plan was. There was never testimony from her or evidence about what the defendant actually said the plan was. However, if the court wanted to view that he, at that point, only intended to go in for an intended beating, we're still looking at what the act of the joint venture is, because the victim was shot in the back twice. So the act, at that point, when the joint venture acted at the seminal moment, he at least, even if the joint venture only intended to go for an intended beating, when the victim was shot in the back and running away and tripping and falling and was neutralized, he still shot him in the back. That is at least third-pronged malice when he shot. And so and if the defendant were surprised that this happened, then he's entitled to a not guilty, not a lesser included of assault and battery. And I don't think that's inconsistent with the trial attorney's argument in closing, saying that he only intended for this to be a beating because it's not a murder, because he didn't know this was going to happen. So I don't think those are necessarily inconsistent. I think the law would support that. I would cite Alibord, 68 Massap Court 1, it's cited in my brief for a similar proposition.
I wanted to ask you about the two shots.
Yes.
There was one evidence he shot in the back, right, and one he shot in the head. That's the back of the head?
It's the back of the head.
And we have any idea which was first, which was second?
I don't believe the testimony was from the medical examiner was clear on that, just that there was a shot in the back of the shoulder and right back of the shoulder, I believe, and left back of the head. And when you watch the video, you can see the victim, the car stop, and this might illuminate the sequence of events. The video is not very clear. I know that it was transmitted to the court, but the car stops. The victim is running. His back is towards the car and the defendant and his group the entire time. He never engages them, and he's running. His back is towards all of them. The defendant goes to punch him and trips and falls and the victim's back is to him, and then, the group is kind of standing there very quickly, and then they run away. So I would suggest that it doesn't really matter necessarily when each of those shots, which one came first. I think it's the victim's back was turned the entire time.
The gun was found, though, right, outside, a couple feet from his hand, from the victim's hand.
Yeah, so it's a starting pistol, and I understand it doesn't really matter in the context of the case, but I would suggest the gun, and in the light most favorable to the defendant, the victim was reaching for it or maybe had it already out as he was turning around, but there was also only the testimony from Coleman that his hands were already out as he was trying to fall. And so I think even the light most favorable to the defendant, inferentially, the gun was already on its way out of his hands and away from him before the shots were fired.
Coleman's statement, though, isn't that she sees him pulling out the gun, right?
Her statement is that she sees him reach for it where it is. I would say it's out from Vasquez's statement after the murder that the defendant saw him take the gun out. So that's the facts, I guess, in light most favorable to the defendant, that it was out as he was tripping, if we're meshing together all the different recitations of it. But either way, at that point, I think, even in light most favorable to the defendant, the gun's already on its way out of his hands and away and being neutralized by the time he's shot.
Do you have suppose we agree with the defendant that there should have been an instruction on assault and battery. Do you have an argument that there was no prejudice?
I would say, I guess, my best argument for prejudice, which is that the jury sent a question back, and I know we don't really read back into jury questions, but this is what we have. It's transcript volume 11, page 4, and they said that they were unanimous as to second-degree murder, but not on first-degree murder, and basically asking, like, can they just come back on second degree? And I would say this suggests the jury found malice no matter what, and they were hung up on deliberate premeditation. So I would suggest this isn't a case where the jury was compromising on necessarily just the lesser included, and they wanted to hold him accountable for something. I understand it's not the strongest argument for prejudice, but I think that is, something to consider.
Well, all they had was the lesser included of second degree, right? In fact, I found it interesting that the jury was sent out around noon, 12:30, I guess, and after closing arguments, and they deliberated until 4 o'clock. They came back the next morning, started deliberating around 9. About an hour later, they came back with that question, right? So couldn't the argument also be made that they spent, and it was, at least a week long, it was a first-degree murder case with many witnesses, right? So they came back after, arguably not a lot of time, right, of deliberation, and said, we can't agree on first degree. So they were hung up on, well, then, second degree, being unanimous on that.
Well, I think they said they were unanimous on second degree, so I think that suggests they found malice. I understand Your Honor's point that it potentially could go the other way as well. But I think that's the best argument I have for prejudice.
In his reply brief, Mr. Sheketoff says that you failed to meaningfully distinguish the case that I can't pronounce.
Gilliard?
Yes.
I think I might have found a way, ruminating over it over the weekend, so I'll give it a shot. In that case, they said, well, there was definitely evidence you could find that the defendant acted as a joint venture with the intent to murder. There's also potential evidence that the jury could find that the defendant in that case only intended to beat up the victim. In that case, it was an affray in a street that I think just started out of nowhere. There doesn't seem to be a relationship between the victim and the group of people who started beating up this girl. And there was one set of evidence from an eyewitness who said the defendant asked for a knife. She handed that defendant a knife, and somebody else had a knife, and nobody knows who inflicted the fatal stab wound, but there's evidence the defendant had a knife and potentially could have stabbed her and make, self-aggrandizing statements that I killed this person. There's also another set of evidence that came in that same eyewitness said, she didn't ask for a knife. I don't know. I gave the knife to somebody else. So from that evidence, there was two conflicting sets of evidence that whether or not the defendant actually harbored the malicious intent by using a deadly weapon. Whereas here, I would suggest, in his Commonwealth's position, there was sufficient evidence, like most favorable to the defendant, that he went in prepared for a gunfight, had armed himself with a gun, and knew that there was a deadly weapon that was going to be used. And so that is how I would distinguish the case.
In Gilliard, the defendant actually makes subsequent statements, multiple statements, I think, to other people, saying, I killed the victim, too, right? Those were some...
Yes, but I think there was also, they could have said that because they were part of the beating, but I think that the difference is whether or not there was evidence of the use of the deadly weapon, and there was direct conflicting evidence of that. And I think that's what matters.
So your point here, I just want to make sure I'm following. Your point is that in this situation, unquestionably, the dangerous weapon was used, a deadly weapon was used by a co-venturer.
Correct.
So, okay.
And the defendant shared that requisite intent.
Right.
But even if the court were to find he didn't, then he would be entitled to a not guilty because he wasn't charged with assault and battery. He was charged as a joint venturer for murder for the 2 shots in the back. So if he didn't share that requisite intent, he's not guilty of anything.
Right. I see your point, and I think I mostly agree with it about the beating being a red herring in the sense that if the jury had been offered a lesser included of A and B and convicted the defendant based on his having punched the victim, he would have been convicted of an offense for which he had not been charged, right? Those punches were not what he was indicted
Right,
for.
and the jury wasn't required to find they were a contributing factor to the death.
Right, but I do take Mr. Sheketoff's point that there's sort of a performance of his intent, of the defendant's intent, right? I'm going to a beatdown. How can you tell? Because that's what I did when I got there. So with respect to whether he shared the intent that there be a gun at the scene or a shooting, I do see the point that it's appropriate to consider what he did when he got there.
Correct. Well, and then I still think that goes to his intent, but that means he doesn't share the requisite malicious intent, so therefore he is entitled to an acquittal, not an instruction on a lesser included. And that would be the Commonwealth's position. I'm happy to answer any other questions on this issue or any other issues in the briefs.
Oh, I might as well ask one question on the peremptory challenge.
Yes.
On the second one, where the judge finds, where they go through it, the prosecutor asked for the jury to be removed for cause. The judge says no. The prosecutor says, well, then I'm going to strike on the same basis. And the judge talks a lot about it and then says, okay, I don't even find a prima facie case. Is your better argument that there was no prima facie case at that point, or that the judge implicitly accepted the reason as adequate and genuine?
I think he implicitly accepted the reason as adequate and genuine, and I think he definitely said it was more than adequate when explaining the reasoning. And then, what would have been better for him to say it was genuine, he said, it would be expected that it would be expected if this person's name did not suggest his Hispanic ethnicity. So I think that suggests he's saying the prosecutor's reason is valid and genuine and honest. And it's not necessary they say those magic words. It's obviously better and more clear for the record, but I think it's implicit that he followed kind of Justice Lowy's guidance, one of his concurrences, that even if you're not going to find a prima facie case, just ask for the reason so that a record can be created and he can make a credibility determination. And I think he did that here.
He didn't really ask for a reason. That it was just offered, sort of.
Well, prosecutors now have been doing that so that the judge can make a ruling on it, so to protect the record on appeal, because otherwise it's structural error.
Okay. Thank you both.
Thank you very much.
Well argued, well briefed, and we'll take it under advisement. Okay, the next case for this morning is Commonwealth versus Palmer, 24P365. Can you see the clock? I'm trying not to block it. I never look at it. If you lean.
Good morning, Your Honors. May it please the Court, my name is Craig Collins. I represent Mr. BYRON Palmer. Mr. Palmer was stopped and seized by the Boston Police Department based on a description of a suspect in a robbery that occurred 12 days earlier, Your Honor. And the description was too general and imprecise to justify a seizure 12 days later, Your Honor. The alleged victim in this case provided a description so vague as to be meaningless. The police attempted to supplement this description by looking at video, but the video on January 2nd showed the suspect, the apparent culprit, leaving the area wearing a mask, so they were completely unable to see the suspect's face, Your Honor. Now, one fact about this case that is very important to remember, Your Honors, is that the police ultimately look at two different videos, but only one video is on the day of the robbery on January 2nd, Your Honor. On January 3rd, the following day, there is another video also in the housing project, Your Honor, and a police officer whose job is to monitor these videos sees a gentleman on that video, and the police consults with other police officers, and the police form the suspicion or hypothesis that this person on the video on January 3rd, who was without a mask, they form the suspicion that this might be the same man from the January 2nd robbery, Your Honor. But this is totally...
I just want just to clarify what the record is here. There's on Record Appendix page 57, there's a picture, a frontal picture against some bricks, the hat and the chain and the face visible. That's the January 6th, the January 3rd picture that's texted on January 6th?
That is correct, Your Honor.
And is that the same, and that's Exhibit 4 at the motion to suppress?
I believe so, Your Honor.
And then the subsequent one, earlier in the Record Appendix 53, there's sort of a side view of a guy next to a car. That one you can see a lighter jacket, and it says your guy is back. That's Exhibit 5 at the...
I'm not in a position to exactly swear to the number of exhibits, Your Honor. I may have to go back and check, but I think my main point is that both of those images, any image of a person without a mask, it's all from January 3rd. It's not from January 2nd, the day of the robbery, Your Honor. That's undisputed, Your Honor.
Go ahead. Can I just ask, so your theory is that your argument is that he's seized.
Yes.
Well, explain to me. Your theory is that he is seized when the police approach him, right? And
Yes,
start
Your Honor.
asking him his name and essentially trying to get information from him? Is that your...
Yes, Your Honor. And there are several factors to consider, Your Honor. And one is, as you mentioned, Your Honor, that the police approach him, and there's testimony in the record that they approach him with the intention of questioning him because he's a suspect in this robbery incident. And Detective Anjos is the name of the detective that he calls out to him with the intention of getting his name. It was the testimony, Your Honor. And there are 6 police officers present, 3 detectives, 3 uniformed officers converging upon Mr. Palmer, and there is also a police wagon nearby. There's testimony in the record to that effect, Your Honor, and there's also record evidence that when they approach Mr. Palmer, he's apparently standing in a group of people, apparently conversing. There are 3 other people there. When the police approach in such numbers, with 3 detectives and 3 uniformed officers and a police wagon nearby, all the individuals run, Your Honor, not just Mr. Palmer. Mr. Palmer runs, but so do the 3 other people, who I think one can draw the reasonable inference that they were frightened by such a large convergence of police officers coming towards them, Your Honor. And again, the detectives were wearing their badges above the uniforms, Your Honor, as per protocol, and the officers in uniform. So it's quite a large number, and I think it fits very perfectly with the Mendenhall description of one of the factors of the threatening presence of several police officers.
So Mendenhall says it's the threatening presence of several police officers, not just the mere presence of several police officers. What it was threatening about them?
Well, I would submit that the testimony in the record is that they're all moving towards Mr. Palmer and towards the group. We have testimony that Detective Anjos called out to Mr. Palmer, and we have the sheer number of 6 police officers, obviously both uniformed and plainclothes, but all armed police officers. I think. And
they're all, at this point, nobody's in the uniformed officers, they're not in cruisers. There's a wagon you see nearby, but they're on foot as well.
Yes, Your Honor, that's correct, yeah. But I would submit that given the high number here, 6 officers, I think, would be intimidating and threatening.
Could you describe what was the area that this happened in? Like, was it was it your client cornered? Was it an open space? What was the?
It's in the parking lot of a housing project, Your Honor, and I think the best description I can give, based on my review of the evidence, well, first of all, there's record testimony that the detectives are approaching and the officers, the uniformed officers, are 10 to 20 feet away. That was the Commonwealth's evidence, and the Commonwealth was saying that they're within sight, they can see them, and it's essentially the backyard of the parking lot of a housing project, and so there were trees, there were some evergreen trees there, and obviously there were parked cars, but it is otherwise an open area.
And your client where does he run to?
The evidence is that he runs, and according to both the evidence and the Commonwealth's brief, that he runs and eventually gives up and surrenders to the police.
Does he run? Is he running through trees? Is he running on a sidewalk? Is he running through?
From my review of the evidence, he's running in the parking lot area, and there's also testimony, now that I think of it, there's testimony by that at the trial by Detective Anjos that he runs across the parking lot and allegedly, according to Detective Anjos, discards drugs when he gets across to the other side of the parking lot, Your Honor. So it's running through a parking lot area is essentially the...
Yeah, actually, I don't think that's Anjos. I think that is Rosa. That's the uniformed officer Rosa who testified.
You're absolutely right that at the suppression hearing, Rosa gives that testimony. At the trial, Anjos was not at the suppression hearing, Your Honor. So, and that's an interesting point. The trial lawyer was very perturbed about this. Anjos did not respond to a subpoena at the suppression hearing, but at the trial, he did give testimony that matches very closely with Officer Rosa's testimony that you just mentioned, Your Honor.
I was actually curious about, so Anjos doesn't testify, neither does O'Donnell, who's the Boston Housing Authority officer who actually seems to do most of the work in this case.
Yes.
Was she called?
Well, I do remember seeing some very extensive discussions about that I don't want to obviously mischaracterize things, but I think it's fair to say that there was some resistance by Sergeant O'Donnell or Officer O'Donnell about testifying. There's frequent discussions by the prosecutor and the judge and the defense attorney about her schedule and not wanting to come in.
Is that with respect to the trial? Is that for the trial or for the motion to suppress?
I think that was for the trial, Your Honor, but I
Okay.
would have to go back and check.
No. All right.
And
Sorry to stop you, but
Oh, sorry.
I want to make sure I've kind of got the framework correct in my mind here. I know that you have taken issue with the adequacy of the description of your client from the first incident to the time that he was actually arrested. He was convicted only of drug offenses, right?
Correct, Your Honor.
Relating to that second day.
Yes.
Is there any legal significance to the description other than the fact that maybe they were watching the video a little more closely when they saw him engaged in what appeared to be a hand-to-hand drug transaction?
Well, he was not, to my knowledge, he was not charged with any hand-to-hand transaction, Your Honor, so I'm not quite sure which part of the record Your Honor is referring to on that. They allegedly see him on January 14th. I think there's some suggestion there that they think that there's possible drug activity, whether it ever got to the level of a hand-to-hand transaction. I don't recall offhand, Your Honor, but I know that he was never charged with that, Your Honor. He was charged with
He's charged with the drugs he tossed as he ran, right?
Yes, Your Honor. And as I said, indicated, Your Honor, the description, in which that the police had when they chased him on this, Your Honor, was so vague. In the testimony, Sergeant Eng, the lead detective, attempted to compare him to both videos, Your Honor, but the most detailed aspects of the description are details that did not match Mr. Palmer at all. For example, in Sergeant Eng's testimony and in Judge Doolin's findings, there's some very granular detail about the shoes worn by the suspect on January 2nd with some metallic color, and they go into great detail about that. But that does not match Mr. Palmer at all. He's not wearing those shoes when he is detained on January 14th. The same with the sweatshirt and the jacket, Your Honor. All of these details do not match his
What about the
appearance.
hat?
So
Is it the same hat?
the hat is what Sergeant Eng relies on. Her testimony is that she identifies him based on size, complexion, hairstyle, and hat, Your Honor. So those are the 4 factors. She does not identify him by face. It's very clear on that. So she identifies 4 factors: size, complexion, hairstyle, and hat. And this is, again, for an instant 12 days later, Your Honor, and I submit that those factors are not terribly descriptive. What it boils
Well,
down
but
to...
it's a Nets hat. It's not a Celtics hat.
It's not a Celtics hat, yeah, that's certainly a cardinal sin in the case, Your Honor, but it is a Nets hat. Interestingly, at the suppression hearing, they don't go into these details about the Nets hat. They talk about it having a particular color. The Nets identification was made at trial, Your Honor. I just mentioned that just in case, Your Honor. But at the...
We're focusing on what was at the motion to suppress hearing, right?
Yes, yeah.
And so, and there's this, on cross-examination, Eng is asked, you agree that Mr. Palmer was not wearing the jacket? No, he's not wearing the jacket. Question, he was not wearing that hat? No, not that hat. So it's not even the hat matches.
That is correct, Your Honor. I think that is a fair point, Your Honor. And so based on, and I would also point out that under Commonwealth v. Cheek, this is by no means a sufficient identification, Your Honor. And at Commonwealth v. Cheek talked about how it's the Commonwealth's burden to present evidence as to how distinctive these items are. In Cheek, the SJC faulted the Commonwealth for not presenting evidence as to how uncommon a 3/4 length goose coat would be. Here, Your Honor, I think the same would apply to both the hat and the dreadlocks hairstyle, Your Honor, and there was no such evidence.
Can I ask you, sorry to interrupt, are the police chasing your client before he starts emptying his pockets, or does he start emptying his pockets as soon as he runs away?
They are chasing him before, and that is clear under the testimony of Officer Rosa, Your Honor, and I can get you the exact citation on that in a moment, Your Honor. Yes, it is on suppression hearing transcript 3, page 66. Officer Rosa testifies that he chases Palmer, and then he saw Palmer discarding items from his pocket. So again,
but your argument is that the seizure occurred as soon as they approached. You don't argue that the seizure started when they started chasing him.
Well, obviously I'm arguing in the alternative, Your Honor. I argue both. I believe, as a matter of law, that the seizure occurred when they approached him. But
the Commonwealth cites a bunch of cases in their brief about how merely chasing after, if we assume that it was just a hello, how are you street encounter, the Commonwealth cites many cases that say just chasing somebody isn't a seizure either. Do you have any response to that?
Well, yes, I disagree somewhat with the characterization, Your Honor. The Commonwealth cites cases which stand for the proposition that merely following a person is not a seizure. But chasing, I submit, is a different matter under Commonwealth v. Stout and numerous other cases, Your Honor. The testimony, the Commonwealth cites cases such as the Russell case where they're following someone through, they see him through a backyard. That's not what happens here. What happens here is the typical Commonwealth v. Stout scenario where the police are actively chasing a person, and as the Commonwealth pointed out in its reply brief, he surrenders to them at the end of that chase, and so under Commonwealth v. Matter, the standard is that the police have to objectively communicate to the person that they're willing to use their police power to compel the person to stay, and when the police are chasing after you, I think that's the classic example of such an objective communication, Your Honor, and we see that Mr. Palmer does indeed give himself up to them. So I think that shows very clearly he was seized at the very least at the time of the pursuit, and I submit he was seized even before that at the time 6 officers approached, Your Honor.
In terms of this chase, I mean, the whole thing, the so-called chase lasts like 3 or 4 seconds, right?
I'm sorry, couldn't you?
The whole chase,
it was
it's
a very
quick.
short chase,
It's
yeah.
not as though it was a, half-mile chase where they're pursuing
Yeah.
him.
Right, that is very, very true, Your Honor.
So anytime the police officers approach someone and that person takes off running, the police have to make a choice between not following and something that you claim is a seizure.
Well, I think that is the case under Commonwealth v. BYRON and numerous other cases in Commonwealth v. WARREN. The SJC and the Appeals Court have made clear that people do have the right to refuse to submit to questioning, that people do have the right to walk away, and unless the police have reasonable suspicion, at the very least, to detain them, then the police do have to simply honor that choice of the person to walk away or even run away. And we have Commonwealth v. Warren saying that flight should be given very little to no weight unless there's reasonable suspicion. And I submit that under these facts, to justify the search, the court below would have had to have leaned into all the factors that Warren states are impermissible, Your Honor. And I think that if the court would accept the Commonwealth's argument and justify the search in this case, I think it would be almost a reversal of Warren sub silentio. It would be a massive blow to civil liberties, Your Honor. And I think Your Honor's question is precisely...
I'm sorry, Attorney Cobbler, I'm going to interrupt you. Your light is blinking. Are there any other questions from the panel? I think we'll have to leave it there.
Thank you so much, Your Honor.
Thank you.
Thank you.
Good morning, and may it please the court. Henry Drembus on behalf of the Commonwealth, under the supervision of Ian McLean, we're asking the court to affirm the defendant's conviction. Your Honors, the defendant was not seized when the officers initially approached him because the officers at that point did not objectively communicate that they would use their police power to coerce him to stay. First, and probably most importantly, they never commanded him to stop. That's clear on pages 52 to 54 of the first volume of the transcript. Sergeant Eng specifically says, "We did not demand he stop." They were just trying to call out and get his name and information. This is just like in Matta, where saying, "Hey, come here for a second," was not a seizure. In Martin, "Hold up," or "Stop, we want to speak with you," not enough for a seizure just because it was more akin to a request for a conversation.
Isn't it a little different to approach somebody, say, on a sidewalk, on a public street, as opposed to back in a parking lot with 6 officers?
It might be, Your Honor. I don't know if that was distinguished in Martin or something like that. I would say the place where it occurs might make a difference, but here, as my brother counsel even discussed, this was a relatively open area, so much so that the defendant was able to flee immediately. Also, just as in, or unlike rather, in Jones-Pinnell, there were no repeated attempts to initiate the conversation. This was not a situation where the defendant made clear that he did not want to engage in that conversation with the officers. Part of that's just because he immediately fled after Detective Andres.
I mean, isn't that kind of like, hey, I don't want to talk?
Yes, Your Honor, that's true. But I think after he fled and discarded the drugs, that was the point where the seizure occurred. So it could be that he, at that point, said, "I don't want to talk," but at that point, the officers had reasonable suspicion based on him discarding the drugs. Similarly,
let's go back to the beginning. So when they first approached him, obviously there's, I think, as a backup argument, you're going to say they did have reasonable suspicion, right? What crime did they have reasonable suspicion of when they first approached?
When they first approached him, they had reasonable suspicion that he had committed the armed robbery from January 2nd. And that was based on the totality of 5 things. At that point, it was the nature of the offense, again, armed robbery where the victim was shot at. Second was the physical description. Third, the distinctive clothing, specifically the hat. And fourth...
So, I mean, the Officer Eng testifies he's not wearing the same hat. It's a different hat.
Correct, Your Honor. I believe, however, that Judge Doolin on page, I think it's 44 or 43 of the defendant's appendix, did find that he was wearing the same hat on the same day and called that one of the distinctive details. And in Sergeant Eng's testimony earlier in, I think, page 52 of the transcript, she described him wearing that same hat on the day of the arrest. So it might have been a little unclear at that point. But again, this was a distinctive hat. According to Judge Doolin, this was a black and white checker hat with a large round logo on the front and a metallic tag on the brim. Additionally, Your Honor...
Is a metallic tag on the brim, is that from the motion to suppress or is that from the trial?
That is from the motion to suppress, Your Honor. That, I believe, is on page 52 of the first volume of the transcript.
Can I pause you on that for a second? Because I want to make sure I understand that you're not arguing that on page 47 of that same volume of the motion to suppress transcript, the witness testifies that Sergeant O'Donnell told somebody that she was watching the cameras and observed the suspect to be out in the parking lot. She believed that he was involved in drug transactions. You're not contesting or contending that that was a reasonable, that gave reasonable suspicion to approach?
No, Your Honor, not by itself. I would say that Sergeant O'Donnell's report to Sergeant Eng that the suspect from the robbery was in that same area is another factor for the reasonable suspicion calculus as to the armed robbery, but not for the suspected drug transaction by itself. And that also, I mean, that I think is one of the factors, and then fifth would be the area itself, the proximity to the crime. And we acknowledge that there is this 12-day difference. However, the police had now seen this person in that same area at 275 Center Street 3 different times, so on January 2nd, on January 3rd, and then again on January 14th. So this was, the officers were able to see that this was sort of where the defendant spent his time. So those 5 things add up to the reasonable suspicion, even if the defendant was seized when the officers initially approached him.
And can you tell me what's your best case for lots of officers, not a stop?
Sure, Your Honor. The best case would be Gomez, and that, I admit, is fewer officers. That was 3 officers quickly approaching the defendant, was not a seizure. That's 453 Mass at 510. But I do want to just clarify for the record specifically that the number of officers, while there were several in the area, this was not some sort of phalanx of police officers approaching the defendant. The record on page 43 of the defendant's appendix, Judge Doolin found that Sergeant Eng approached the defendant with the 2 detectives, that the uniformed officers were 10 to 20 feet away, and then on page 65 of the 3rd volume of the transcript in Officer Rosa's testimony, he specifically said that he didn't even see the defendant until after the defendant had started running. So it's unclear whether the defendant was able to see the uniformed officers. Additionally, at that time, my brother counsel pointed out the police wagon, the sirens were not on, the lights were not on. There was no objective communication when they approached that they would use their police power to coerce the defendant to stay.
So when did they develop reasonable suspicion for the drug deal?
For the drug deal, it was when the defendant had discarded the drugs as he began to flee.
And that's after the chase had already begun, though, right?
I would dispute that order of events, Your Honor. I would say that, let's see, I think page 43 of the defendant's appendix, Judge Doolin found that the order of events was the defendant immediately fled on foot, discarded items from his pockets, and was quickly apprehended. So the order of events based on Judge Doolin's findings seems to be that number 1, the officers approached, again, at that point, not a seizure. Number 2, Officer Anjos called out just to get the defendant's name and information. Number 3, the defendant immediately fled on foot. Number 4, this is page 54 of the 1st volume, immediately upon fleeing on foot, he began discarding drugs from his pockets. And then, number 5, the officers began the chase, and at that point, the seizure occurred, based on the reasonable suspicion of the drug transaction.
So I asked Attorney Collins to distinguish the cases that you cite on about a chase or is not a seizure, and he said your cases are all about merely following, and they're not like Stout where there's actually a chase. So how did you respond?
I don't think it's particularly important, Your Honor, honestly, whether the point of seizure occurred when the chase began or when in that 4-second period or after that 4-second period the police caught up to him, simply because based on the order of events that Judge Doolin found, the police already had reasonable suspicion of the drug transaction when they began the chase. So while we made that argument in the brief, I don't think it really changes the result here. Unless Your Honors have any further questions?
Seeing none, I just, for the record here, I mean, and again, excellent job arguing. No offense, Attorney Collins, but this is a law student here. Terrific job. You've got a good future ahead of you. and the case is submitted.
Thank you, Your Honors.
Okay, we're going to hear one more case before we take our customary break, and that's Commonwealth versus Allen, 24P359.
Good morning, Your Honors. May it please the Court, my name is Esther Horwich and I represent Mr. Allen. In this case, the Court should reverse the conviction of Mr. Allen where the prosecution failed to prove the elements of larceny, specifically that there was an unlawful taking or a wrongful taking in carrying away property of another, and with specific intent to permanently deprive the owner of that property. In this case, there was no trespassory taking. It was a giving of checks for work to be performed. And that work was performed for several weeks to a month after the last check was given. And the larceny is a specific intent crime, and the burden is on the prosecution to prove that he had the specific intent that coincides with the taking of the property. The cases that the prosecution relies on to argue that intent was not necessary at the time of the taking all involve trespassory takings, wrongful takings, where the trespass was ongoing at the time of the intent was formed, and thus they are inapplicable to Mr. Allen's situation where there was no trespassory taking.
So you make several different arguments, about the same point, and your first one is sufficiency of the evidence.
Yes.
And looking at the evidence in the light most favorable to the Commonwealth, couldn't a jury find that his intent from the beginning, even though he did some work, was to not complete the work and to take the money and run?
Well, in light of the amount of the work done, I would suggest no. But if that were the case, this would be larceny by false pretenses, because in regular larceny by stealing differs from larceny by false pretenses or embezzlement, because in larceny by stealing, there has to be a trespassory taking. There has to be a wrongful taking. The ownership of the property remains in the possession of the owner for a larceny. The ownership remains in the possession of the owner, whereas the possession of the property remains in the possession of a thief. Whereas for the other two types of larceny, there is a giving of the property. So that's the big distinguishing factor in the two types of larceny. And were this a larceny by false pretenses case, True, Commonwealth versus True, would say you can't infer that there was an intent just from the fact that the contract was not completed. There has to be, if we look at Commonwealth versus Lee, which was a case that was decided after I filed my reply brief, 104 Mess App Court 725, I believe Justice Hershfang was on the panel for that one. The intent to commit larceny by stealing is determined as of the time of the commission of the crime, which in this case would be the taking. So the cases relied upon by the Commonwealth involve trespassory takings, which are not what occurred here. There was no trespassory taking. And in those cases, if there's a trespassory taking, there's sort of a legal fiction saying that the wrong is ongoing. The trespass is ongoing so long as that person holds the property. And therefore, the intent to steal coincides with at least a portion of that trespass. But that didn't occur in this case. The facts just don't demonstrate that that Mr. Allen had any sort of intent to steal at the time he received the checks. And he continued to work for weeks afterwards. And if one looks at the work that he did, much of it, some of it was unsatisfactory, some of it was incomplete, but there was a tremendous amount of work that was performed. He put in cabinets. He redid 2 bathrooms. He built an island. He put in a vanity. He painted. He bought a refrigerator. He bought a dishwasher to install. And at some point, he was hospitalized. And when he left, his papers and some tools and his saw still on the property, which is not indicative of someone who is just going to take the money and run. So there weren't grounds for larceny by larceny by stealing, because there was no wrongful trespass. There was no grounds for a larceny by false pretenses, because work was performed long after the payments were received. And there was no grounds for embezzlement because there wasn't any sort of relationship, fiduciary relationship between the 2 parties. So in essence, no evidence of larceny was introduced. That's why a required finding of not guilty is appropriate in this case. He purchased supplies, he purchased fixtures, he had workmen come over. Yes, it wasn't satisfactory, but there's a difference between a tort, a wrong, a civil wrong, and a criminal action, and we don't have the mental intent coinciding with the taking of the property in this particular case. Now, I go into detail in my brief about why it's not any of the other types of larceny. If there are no questions on that, I'll just continue onward.
It seems to me that everybody agreed, both at trial and on appeal, that it's only this larceny by stealing that is at issue.
That is correct. The prosecutor specifically declined to go forward. There was a discussion on it. He declined to go forward on the larceny by false pretenses, and there certainly was no evidence of embezzling. So in this particular case, because there was no evidence to support the claim, I'm arguing that a required finding of not guilty should be entered. We don't even have to consider the other issues. I will submit a 16L letter on this, but if it's not necessary, there are cases that say it's not necessary to reach the trial error issues where insufficient evidence has been introduced to of the charges. And these include Commonwealth versus Baez, which is a 2024 case, 494 Mass 396. And I will submit this in a 16L. Justices of Municipal Court versus Leiden, 466 U.S. 294.
Well, this is for the proposition that if we agree with you on the required finding, that's the end of the story?
That's the end of the story.
I don't think we need a 16L letter on that. I think we understand that's the law.
Okay. Then I won't submit one. And then with regard to the jury instructions, I would submit that they were incorrect, that there should have been, they permitted Mr. Allen to be convicted of larceny by a single scheme, absent evidence of an unlawful taking of the checks, and absent evidence that Mr. Allen had the criminal intent to steal the money at the time the checks were given to him. And I believe it's fairly explanatory in my brief, but if there are any questions, I will address that.
Don't you think the instruction on a single scheme instruction was given that requires, even though time may elapse between the incidents, they're not separately motivated, but were part of a general scheme or plan. So it seems to me that would require them to have the same motivation for all three, taking all three checks.
I don't think it said that. I don't think it's clear from that, and certainly the judge's supplemental instruction saying intent can be formed at any time would have confused the jury, because they could have found, well, he decided at the time of, he ran into her in Home Depot, he owed the money and he wasn't going to pay her back, and that's larceny. You can do that based on that instruction, and that's not correct. So I would argue that...
Those are all unpreserved, though, right?
Those were unpreserved, but where it results in a conviction on insufficient evidence, I would suggest that that creates a substantial risk of a miscarriage of justice. So even those were unpreserved. The one issue I would like to address, though, is the prosecutor's comment saying, "We heard exclusively from Ms. Chalmers on the stand." And the reason I am addressing that is for two reasons. But before I get into those, let me just say that the defense counsel did object to that, and the judge said that she missed the statement. She didn't hear it, in other words. So she did not give an instruction, and it was just part of the general mass of instructions that she talked about, burden of proof. My concern is that on page 34 of the prosecution's brief, the prosecutor argues that this remark was not error. And taking that position is of concern because he argues that it was not a comment on the defendant's silence. Well, I would argue that it certainly was, as well as his failure to produce evidence to counter it.
I mean, wasn't it really, I mean, it was not the most perfectly worded thing, but isn't it just, there's only one witness here, and then going on to describe the witness's testimony?
Well, I think if we look at Demansky, it says a comment that is reasonably susceptible of being interpreted as a comment on the defendant's failure to take the stand is improper. And had the prosecution argued, well, this comment was probably not appropriate, but it didn't do any harm, I wouldn't be arguing in front of you. But the prosecution is saying, hey, we can say this. It's not error to say this. And that's where I suggest the problem lies. And also, the brief says the judge found, and I quote, that the prosecutor's remark did not give her the impression that the prosecutor was commenting on the defendant's silence. To correct the record, the judge simply said she missed the comment. She did not make a statement saying that it was deciding the comment one way or the other. She simply said that she missed the comment. So I would argue that even though this court does not have to consider this matter if the court finds that there was insufficient evidence, it might behoove the court to do so just to confirm that this is not an acceptable or a good statement that the prosecution should make at trial. So unless there are any further questions, I would just say that in light of the process...
Even if it was error, though, I mean, there's a very strong presumption of innocence, and defendant doesn't need to testify instruction, right? I mean, there's no prejudice from it.
There was, but Demansky states that
I mean, even if it's should have not, shouldn't have been said. In this case, there's no harm from it.
I would argue that there is harm.
So the jury's going to listen to the prosecutor's ambiguous statement about the defendant didn't testify when the judge says you cannot take that. They're going to listen. They're not listen to the judge. They're going to listen to the prosecutor.
I think that if the judge had stopped the jury at that, stopped at that point and said and reinforced the matter, that would have been one thing. But by just tossing the judge's statements, general statements, in a mass of numbing instructions, because there are a lot of instructions the jury has to pick up, and not citing that particular instruction, harm was caused. My concern is I just believe that instruction was not ambiguous. I just think it was wrong. And whether or not this court finds sufficient evidence to state that it was sufficient to flip the case, I just think this court should come down and state that this was not an appropriate statement, and prosecutors should not comment that the sole evidence came from their witnesses. In light of the prosecution's failure to produce sufficient evidence to demonstrate, to support a conviction, this court should vacate the conviction and order the entry of a required finding of not guilty. Thank you.
Good morning. Alexander Jones for the Commonwealth, and may it please the court. This court should affirm the defendant's conviction of larceny by stealing that was entered in the West Roxbury Division of the Boston Municipal Court after a full jury trial. The evidence was sufficient to show larceny by stealing, not any other theory of larceny. That was never presented to the jury. The evidence was sufficient not only because the law as it stands does not require that the intent to permanently deprive an individual of property needs to occur at the exact same moment of the taking and carrying away, but also because the evidence presented to the jury can lead to an inference that that intent did actually occur and did exist at the time of the taking and carrying away. The taking and carrying away in this case is every instance that a check went from the victim, Ms. Chalmers, to the defendant, Kelly Allen. This was a larceny by single scheme case, meaning that the intent carries over for all three of the transactions that were specifically testified to by Ms. Chalmers, all amounting to
Well, I
several
mean,
thousand dollars.
the intent doesn't carry over retroactively. It doesn't, I mean, it has to, each of the takes has to be motivated by the same intent, right?
Yes, that's what I mean, Your Honor. Not that you have intent on the third check, meaning you also had intent on the first check retroactively. But you raise an interesting point, which is perhaps the main part of this appeal, which is that in a larceny case, and really any case where intent is the dispositive issue, proof of intent almost always comes sometimes long after the actual intent occurs. That is the case in this case, and that is the case in a venerable case, Commonwealth v. Rubin, that is cited in the defendant's brief and is from the pen of Justice Holmes back when he was just a justice on the SJC, not even Chief Justice. But in that case, and similar to this case, there was an entirely consensual handing over of a horse to an individual who eventually took that horse and secreted it away and did not give it to its eventual intended recipient. In that case, there had been a horse sale. The horse was supposed to be transported by what Justice Holmes called a boy. The boy gave it to another individual. The other individual took that horse away. And eventually that horse was discovered far away from where it was supposed to be, held on by the individual who took the horse away from the boy. It was an entirely consensual case, and the proof of the intent to permanently deprive the owner of the horse came long after the actual taking occurred, but the intent occurred from the moment of the taking. Just so here, we have 3 or 4 facts that this court can look at that show the intent existed all along. Number 1, the state of the work or the status of the work itself. If your honors look to the trial transcript pages 95 through 99, you will see repeated instances of incomplete work. You will see from pages 62 and 89 through 90, repeated instances of the defendant stringing along the victim, suggesting new projects that she wasn't even interested in at the time. And last but not least, the defendant completely stopped coming on pages 98 and 99. And then of the final clinching proof beyond the state of the work and the status of the defendant's presence is that on page 129, the victim gives an account of the interaction that she had with the defendant at Home Depot, where he agreed that he owed her money, and then he did not pay her back. The timeline between that statement and the initial complaint is important. The defendant not only didn't pay her back over the course of days or weeks, he didn't pay her back over months. There was testimony from Mrs. Chalmers, the victim, that she actually tried to perfect service in a civil suit. She failed to perfect service. Only after that did she seek a criminal complaint for larceny, and the criminal complaint for larceny issued, depending on how you view her testimony, around 7 or 6 months after the defendant agreed that he owed her money and then started not paying her back.
Had the statute run, the civil statute of limitations run by the time she failed to perfect service of her civil suit?
I'm not sure about that, Your Honor. I just don't know the answer to that question. The answer to why she didn't pursue a civil suit presented on the record is that she failed to perfect service.
Can I talk about the horse for a minute? And I will confess I didn't read the horse case, but I read the bag case, Titus, which is similarly venerable, 1874. And
Horry.
Yes, Horry. And that's the one where the guy finds lost goods and takes them away. And it turns out it's not finders, keepers, losers, weepers, because if you intend to take it away, you can actually be guilty of larceny. So then everybody's weeping, I guess. But what the SJC said in that case was, if at the time of first taking them into his possession, he has a felonious intent to appropriate them to his own use and to deprive the owner of them, and then knows or has reasonable means of knowing or ascertaining who the owner is, he may be found guilty of larceny. So if you find a bag and you don't know whose bag it is, I guess it's not larceny, because how would you return it? But if you realize you could return it and you don't, you have the intent at that moment not to return it, that's larceny. That doesn't sound to me like what happened in this case, which is that the guy came, he took the checks, he did the work. It may be that the work stunk. It may be that the work wasn't exactly what was wanted. Why she continued to hire him for additional work and give him more checks if that was the case is unclear to me, but it's hard to find a contractor. Maybe that's why. How do you distinguish Titus and then the cases for the 100 and whatever years since then, 150, that say it's the intent in the moment of taking that matters?
I'm not necessarily trying to fully distinguish them in this case. I am arguing that the intent did exist at the time of the taking. And I'm also pointing out that the law as it stands does also say that intent doesn't necessarily have to be at the same time. And for that, I cite Commonwealth v. Lent, which I admit readily is not on all fours with this case at all. That is an attempted kidnapping at gunpoint where the kidnapper grabs a backpack and the victim sheds the backpack to flee. Clearly, the intent was not to steal the backpack at the time he grabbed it. But future cases, such as an unpublished case from a panel of this court, Commonwealth v. Buxton, show that the intent necessarily doesn't have to be at the same moment as the taking and carrying away. However, I am arguing that although there is that concept in the law, in this case, the jury had sufficient evidence to infer that the intent to permanently deprive existed at the time of the taking and carrying away.
Why isn't this a larceny by false pretenses case?
So the issue here is that the larceny by false pretenses elements, I think, don't apply. And that is, I think, shown in the charge conference that is reflected in the record. If I may, the elements for larceny by false pretenses are very different from larceny by stealing. And if I may just cite them. So first, the issue is that the larceny by false pretense elements are very different and may or may not have been met by the facts of this case, but that's reinforced by the True decision. That's the name of the case. From the True court, the court wrote that, quote, the mere non-performance of a promise is insufficient evidence of, quote, deception as to a person's present intention to perform a promise. And that holding, however, is limited to the specific crime of larceny by false pretenses, but because of that holding, the Commonwealth would have a very narrow road to hoe, a very steep hill to climb, and I think would not be able to meet its burden at trial if this were to go forward to a jury on a larceny by false pretenses claim.
So how do you respond to Attorney Horwich's argument that a larceny by stealing is just the wrong charge here because it's a non-trespatory, however you say that. I was trying to write that down, non-trespatory taking, that the money was voluntarily given.
I understand the point, and to that I answer with Rubin as well, which was also a non-trespatory taking and carrying away, entirely consensual.
So your answer is it doesn't have to be. It doesn't have to be non-trespatory for it.
It does not have to be, and further evidence of that is shifting slightly to the jury instruction question. The model jury instructions, which the trial judge largely tracked here, don't include any of the language that the defense wishes that it had, such as trespatory or non-consensual, but the law also does not require that, as shown in Commonwealth v. Rubin. And unless there are any other questions on that issue, I will proceed to the final, the issue of the closing.
You were the trial lawyer, right?
I was the trial prosecutor, yes. So I will not say that you have to accept my word for the fact that this was not a comment on the defendant's silence. However, this court should accept the trial judge's word on this. The trial judge did actually make a finding in the moment because the defense attorney did timely object. The judge said in full, once the defendant had objected specifically to the word exclusively, the judge said, quote, "I missed that. If in fact I didn't, and I was listening to both of you carefully, he may have said that, but in the context in which he said it, I didn't walk away with that impression. I'll note your objection, and I'm going to give that instruction." To provide a little bit of context to this statement about context, when the judge says, "I didn't walk away with that impression," the judge was responding to the defense attorney saying that, quote, "the Commonwealth basically said, hold it against the defendant that he didn't testify," end quote. The judge was absolutely right to find that there was no reason to think that in the context, this was a comment on the defendant's silence.
What do you think the prosecutor was meant when he said, we use that word exclusively?
The prosecutor, being me, was referring to the fact that there only was one witness. And the fact that all the evidence came in through that one witness was a fact before the jury. And so even if the prosecutor, me, had not said exclusively, it would have been obvious through the discussion of the evidence that the jury was only considering one witness and only considering one source of evidence.
Doesn't that kind of cut against you, though? I mean, if it would have been obvious to them, then why say it other than to comment obliquely on the defendant's silence?
Would it have been better left unsaid? Absolutely. But even when said, it is not a comment on the defendant's silence. It's merely a comment on what the evidence was. Now, I understand that that might be a fine distinction. The evidence only came from one source. Therefore, the defendant did not testify. But that's actually several steps of inferential leaps that I did not make in my closing, and that statement cannot bear out, because the statement really is only one word. It's the word exclusively. And that is insufficient to find that the prosecutor made a comment on the defendant's silence. Coupled with the fact that the judge gave a proper and fulsome instruction regarding the defendant's right to silence, there was no error and there was no prejudice in this case. If there are no further questions, I will rest on my brief.
Seeing none?
Thank you.
A third time in a row, another really well-argued case, and it's submitted. I think I said we would take a break at this point, and we will. We'll be back at about 10 after 11 for the MOUCHARITE case. That'll be and then we'll hear the MOUCHARITE will be at about 10 after 11.
All rise. Court is open. Please be seated.
Thank you. We're back on the record with 24P364. Adam, you'll correct me on the pronunciation. MOUCHARITE versus Carter. You have the floor. The light goes on when there's a minute and a half left. The yellow light goes on when there's a minute and a half left, and then when it turns red, that's the end of the 15 minutes.
Good morning, Your Honors. May it please the Court, my name is Adam MOUCHARITE, and I'm representing myself in this case. Quote, I never wanted you on my team. I want my own people, end quote. This is a statement that my manager, Mr. Jassi Singh, made to me on March 15, 2022, during a meeting I had with him. The purpose of the meeting was to discuss what had happened to my bonus, which I was told on February 14, 2021, that I was getting, which I never received. At that meeting, he revealed to me for the first time that he had completed my performance reviews in August 2021 and in December of 2021.
It's a little unclear to me on which supervisor. There's some discrepancy on who the supervisor was, right? Which supervisor is this that told you?
The only supervisor I had from June 7th, 2021 until my last day.
Mr. Singh, right?
Mr. Jassi Singh, correct. Your Honors, this statement was made to me at that meeting where he revealed to me for the very first time that he had completed my performance reviews in August of 2021 and in December of 2021. He revealed to me that he had rated me underperforming. When I asked him how he came up with underperforming, since we never met to discuss the job or expectations or performance priorities, he said he got feedback, and he gave me two names. I asked him from who. He gave me two names. The first name was Amit Sharma, and I told him that did not make any sense because Amit was a contractor who reported to me, and he was became a full-time employee in November of 2021, so he couldn't have possibly gotten any feedback from him. The second name he mentioned, I asked him who else. He mentioned Saadi Valaru. I told him that I had no contact with Mr. Valaru until October 3rd of 2021. When he asked me, he told me he was overwhelmed, and he asked me if I could take over some of the applications which I had managed for 10 years. Being familiar with the applications, and I fully owned them for 10 years, I accepted. That was the only contact I had with Mr. Valaru. Your Honor, the district court did not provide an opinion for its decision.
That's okay. What we're reviewing is the decision by the examiner, by the department.
Exactly.
So-
That's what I was going to say. Thank you.
Can I ask you a question? So you, on March 16th of 2022, that's when you went into the HR portal and you looked at your reviews, right?
Early in the morning. That's correct.
Okay, and you saw that they were negative, and you emailed I believe it was Ms. Childs, who said she would speak with Mr. Singh. And then the very next day, you submitted your letter of resignation.
Yes,
with
correct.
two weeks' notice, right? And
Yes.
that was, and so you didn't wait for a response from HR or from Mr. Singh before you made the decision to.
Yes, Your Honor, the circumstances at the time, and the hearing officer made the fact finding, fact number 20, I believe, states that at that time, following my meeting with Mr. Singh on March 15th, I was upset. I had stress, anxiety. I had heart palpitation. I have a heart condition. So I had my first heart attack in 2019. And I couldn't sleep. This was confirmed by the therapists whom I saw for nearly 3 months. And the therapist report can be found in the evidence folder. I'm sorry, I didn't write it down. And also on my resignation letter. So the circumstances at the time, I had a mental breakdown, and I testified to that, and it was backed by the therapist report, and I wrote it on my resignation letter. I testified in response to your honor. I testified that I did not trust HR, and that was based on my own experience in 2008. And I testified that HR has a culture that if you complain, they put a target on you. My own experience taught me that if I want to keep my job, I shouldn't complain. And that's why I didn't complain for such a long time. I was excluded from the day I started reporting to Mr. Singh. I was excluded from all team meetings, and he held daily meetings with his team. I was excluded from all email communications, from all activities, all trainings, okay? This was pure discrimination because all my teammates or colleagues were from India. Mr. Singh was from India. His manager was from India. So I was the only person not from India in his team. And I was the only person who was outcast. So the discrimination was pervasive and was repeated.
Can you explain, I don't quite understand how, if there was discrimination, why is that not a lawsuit against them for discrimination as opposed to having to do with your employment benefits? Like why does discrimination get you unemployment benefits?
Because repeated and pervasive discrimination is considered by law as unreasonable harassment. And for unreasonable harassment under Chapter 151A, Section 25E, an employee who is subject to unreasonable harassment need not take any reasonable steps to preserve their employment. The hearing officer saw it the other way, misapplied the law. She stated that I did not make reasonable steps to preserve my employment, when the law says otherwise. In this case, for sexual, racial, and unreasonable harassment, an employee need not take any reasonable steps, and that's part of the law, 151A, Section 25E, as well as 430 CMR 4.05, but I believe C3. So here, the hearing officer misapplied the law, committed an error of law. The hearing officer did not, and the hearing officer also had certain facts in her fact findings that are not supported by the evidence. Specifically, facts number 6, 7, and 8. Going back to fact number 3, she states that the claimant's direct supervisor was the managing director. Then number 4, the director, who was Mr. Singh, was the claimant manager beginning 2021. Number 5, at no time between 2021 and March 15, 2020, she said 2023, it's a mistake, 2022, did the director meet with or otherwise contact the claimant to discuss his work or job performance?
You agree with that, Mr. MOUCHARITE,
Yes.
right?
That is a fact. However, what I don't agree with, and that there is no evidence, is fact number 6. The director tasked another employee A, who is Mr. Valerio, to manage the claimant and enter the same in the employer system, but such was never registered in the employer system.
Does it matter to your argument if the hearing examiner was wrong about that fact?
Well, this false statement came from the witness.
Right.
There is no evidence to support that.
Well, statements from witnesses are evidence. So
But-
there may be no additional evidence.
There is evidence, Your Honor, that shows that it was Mr. Singh and only Mr. Singh who was the manager.
And the hearing officer does find that in number 4.
Right. But this statement made by the witness, State Street witness, was to cover up for the discrimination that I encountered. Oh, basically saying Mr. Singh was not really his manager. That's why he was excluded from all this.
And so I just want to make sure I'm following this part of your argument. So your claim is that if the hearing officer had properly acknowledged or properly understood that this story about Mr. Valerio being your manager was actually false and had been made up to cover for Mr. Singh's discriminatory behavior, that would have been part of what the hearing officer could consider on this question of whether you needed to make reasonable efforts to keep your job or whether you have been discriminated against?
Correct, Your Honor.
Okay.
So fact number 7 also says the claimant was not advised that the employee A was his manager.
That's true, right? You agree with that? Nobody
Yes.
told you this guy who was not your manager was your manager?
Correct, Your Honor. But it goes beyond that, because this is illogical and makes no sense. I may be wrong, but I don't know any employee in the world who doesn't know who they report to, and the new manager never meets with them and they discuss with them work it just doesn't make any sense.
What evidence was there that the hearing examiner had? In other words, we can't take anything new from you. So when we ask you about evidence, we're asking you about things that are in the record from the hearing. What evidence was there about the review process? Because you were at State Street for a long time, right? So before Mr. Singh was your manager, is there evidence in the record about how frequently you met with your previous manager for reviews?
Absolutely. In the evidence, there's a State Street policy, which can be found on the performance evaluations on plaintiff's record appendix number 3, page 30 through 42, as well as the defendant's supplemental appendix, pages 027 through 038.
So there's a policy, but is there any evidence about whether that was being followed in the years before you reported to Mr. Singh?
I testify to that.
Okay.
And speaking of the evaluations, Your Honors, sorry. I have provided in the evidence my performance reviews dating back to 2015. Most of them say I exceeded expectations. As late as April 2021, I achieved on all goals. 2 months after Mr. Singh became my manager, without ever meeting with me to discuss the expectations and performance priorities, he rated me underperforming. He never notified me with that, which is a violation not only of State Street policy, but a violation of Massachusetts General Law 14952C. Your Honor.
Minute and a half, so make sure you get to the things you want to tell us, okay?
Yes. In addition to the disputed fact, which I just mentioned, under 151A, Section 25E1, an employee who quit his or her job is not entitled to benefits unless they can prove one or two conditions. The first condition is they left for good cause attributable to the employer, and the second one, if they left for urgent, compelling, and necessitous reason. I believe I've satisfied both, not just one exception, but both exceptions. With regards to urgent, compelling, and necessitous reason, hearing officer's fact number 20, which can be found on Record Appendix 3, page 25, she wrote, during the evening of March 16th, 2022, the claimant was upset and experienced stress and anxiety because of the poor performance reviews. The claimant's blood pressure was very high. He was experiencing palpitations and could not sleep. Okay? This fact is supported by the therapist report. I saw the therapist for nearly 3 months, and the therapist found, in addition to these, that I also suffered from depression. The hearing officer said...
I'm sorry to interrupt. Your time is up. You just take 30 seconds to sum up, okay?
Yes, Your Honor. The hearing officer committed several errors of law here. Unfulfilled promises. I was definitely promised a bonus, and it remains unfulfilled even today. Okay, that is a good cause attributable to the employer for leaving. Urgent and compelling. Case laws tell us that, especially CONNIE Hospital versus Department of Employment Security, says that an employee who has reasonable belief that their health is at risk because of work are entitled to benefits.
Okay, thank you. We'll have to leave it at that.
Thank you.
Thank you.
Good morning, Your Honors. Catherine Fahey, Assistant Attorney General, appearing on behalf of Appellee Department of Unemployment Assistance. I'd like to start by addressing Mr. Moucharite's factual concerns. I think it's clear from the underlying decision that the board credited that there was, for lack of a better word, some dysfunction around Mr. Moucharite's supervision and management from the time that Mr. Jassi Singh took over for his former manager until the time of his departure in March 2021. And so to the extent that Mr. Moucharite disputes certain facts as to the chain of events or what was communicated to him or not, it is clear from the face of the underlying decision that he was not being met with and that he may, in fact, as the decision recognizes, have had a valid workplace grievance, and that there were other issues with the evidence that he put forward as to whether he was entitled to unemployment benefits. So I'd like to start from that place. Additionally, unless there are questions on it, I'm happy to move directly to Mr. Moucharite's concerns about the involuntariness and about racial discrimination and set good cause aside for now.
Actually, no, I had a question about good cause. I mean, the standard is good cause for leaving attributable to the employing unit?
Correct, Your Honor.
What does that mean?
So I have a couple of examples, Your Honor, because it is a particularly, I think, ambiguous phrase. So good cause is essentially some circumstances prompted by the employing unit. Some examples in the case law are hazardous working conditions or equipment, transfer to an unsuitable work environment, unilateral change of an unemployment contract, or the reasonable belief that a job was in jeopardy because of pending layoffs. And although the language is merely that you need to establish good cause attributable to the employing unit, there is sort of a secondary piece of this, which is that you need to show that you made reasonable efforts to preserve your employment prior to departure, or that it would have been futile to do so. And futile meaning that had you made those efforts, they would not, the employing unit would not have agreed to them, or that even if the employing unit had agreed to them, it would have been insufficient to redress the circumstances that would have caused your departure.
Okay, so one more question on good cause. If an employee is fired for underperforming, for bad performance reviews, can they get unemployment, or is that?
I can't address that sort of in detail, Your Honor, but it's under a different subsection of the statute, and my understanding is that is also a fact-intensive question. I believe that is E sub 2, and we are under E sub 1, which is circumstances of voluntary departure.
Okay, thank you.
So turning to Mr. Musharite's focus on involuntariness and setting aside, although the department does maintain that certain arguments were waived, setting aside our waiver argument and focusing specifically on whether Mr. Musharite's departure was involuntary, or rather whether the review examiner's decision as to involuntariness should be affirmed here, I'd like to sort of bring the standard again to the forefront, which is that Mr. Musharite would have needed to show by substantial and credible evidence that the circumstances were urgent, compelling, and necessitous to render the leave involuntary. And in considering the involuntariness of departure, the review examiner can consider circumstances such as whether the individual made reasonable efforts to preserve employment, as would indicate his desire to continue working at the employer. So reasonableness of the employee's beliefs and employer's actions are factual questions. These are well within the discretion of the examiner, and involuntariness of departure has been categorized by the appeals court as a peculiar one for the board. The nature and circumstances, although the focus is on the reasonableness of his beliefs, he does not need to prove that it was in fact the case that his health condition forced him to leave. It merely needs to be that it's a reasonable belief. The nature and circumstances of the compulsion that causes the departure is addressed by the review examiner on an objective basis. So in this case, the review examiner considered Mr. Musharite's health circumstances surrounding the time that he tendered his resignation. The review examiner credited that he was in the midst of essentially a panic attack, that he had underlying heart issues that were a valid concern, but also that the circumstances were not involuntary, where there were other facts in the record, including that Mr. Musharite had a heart attack and had successfully taken a leave of absence previously, and so he understood that could be available to him. And also that where he testified that he had concerns about HR based on interactions in 2008, that his concerns about HR were not supported by the record and were not reasonable, because he had no reason to expect that the same folks he interacted with and had negative experiences with in 2008 were still with HR, or any other sort of indicia that HR could not be trusted in this circumstance to assist him. And further, as to all of the factors that could have supported unemployment benefits here, the review examiner found that Mr. Musharite engaged in no efforts to preserve his employment. He did not, ask for a leave of absence before he sent over that letter. He did not wait for Ms. Childs to provide a response. I understand health circumstances notwithstanding, that it is reasonable, and the review examiner is entitled to deference, having considered that he made no efforts to preserve.
What do we do with the fact that the review examiner made no findings about Mr. Moucharite's claims of discrimination, which I understand in the brief, the Commonwealth takes the position those were waived. It's hard for me to understand how they were waived when it's like on page 1 of the claim for unemployment benefits that Mr. Moucharite submitted to start this, and appears throughout the administrative record. How do we sort of get around the fact that, if you'll assume, just humor me, that those were raised, that there are no findings?
Absolutely, Your Honor. So my understanding is that the board, or the review examiner, need not make findings as to each and every issue, but setting that aside, on the entirety of the record, the review examiner concluded that Mr. Musharite tendered his resignation because of the non-payment of a bonus and because of the negative reviews and not because of discrimination. And so I would submit that implicit, sorry.
Sorry, if I don't say something right away, I forget it. So you said not because of discrimination, but that's not actually an articulated piece. So I think what you're saying, I just want to make sure I'm hearing you correctly, is that the implicit in the determination that the reasons that Mr. MOUCHARITE resigned were economic and financial is also a determination that it was not caused by any workplace discrimination?
Correct, Your Honor. And I would say, to the extent you are inclined to go there, or this is a sort of a next logical question, there is no basis to remand as to inquire as to the racial discrimination issue because the review examiner was not required to make a specific finding, and particularly where the record does not support a claim that Mr. MOUCHARITE departed because of racial discrimination. The evidence is quite limited as to this issue, although, as you point out, it is on the face of his DOA application. It is in his resignation letter. But there's nothing prior to tendering his resignation to reflect that Mr. MOUCHARITE raised this issue or that this was an ongoing concern, including his conversations with Ms. Childs. Neither of them testified that he raised discrimination in his pre-termination communications.
Can I ask just a question for clarification, because I'm a little confused here. Where in the record is the operative decision of the review examiner?
The operative decision of the review examiner, I can point you to it at the back of my brief. As you might have noticed, I submitted a supplemental appendix because I had some issues with Volume 3, where the review examiner's decision would be. And so I would direct you to the Department of Unemployment Appeals brief at page 30 for the decision.
I thought it was also at Volume 3, page 22 of the record appendix. But I can figure out if that's...
Did you say page 30 of your brief?
Yes, Your Honor. And it's also, I believe, at page 33 of the supplemental appendix, but I apologize, I didn't bring everything over with me.
I don't have a page 30 of your brief.
No, I don't
either.
But
Seems
I'm looking
to end at 27.
I'm looking at page...
My addendum, excuse me.
What's page 120, what's 193 of the addendum?
I don't have an addendum.
Which is entitled decision.
Oh, I'm sorry, Your Honor. There were two decisions in this case. And so after an initial decision and an appeal by Mr. MOUCHARITE to the district court, the board agreed to remand the case, and there was a second decision. And so the operative decision is at the addendum to my brief. I believe it's also in the addendum to Mr. MOUCHARITE's brief, and I will get you the page number that's in the supplemental appendix.
Because I'm looking at page 194, 195, there are findings about discrimination.
Yes, that is in the first decision.
Okay.
And so there was an entire proceeding before the board and then an entirely new second proceeding, and it is the second proceeding that is at issue here.
Which is first in the supplemental appendix.
Correct. Correct. And again, with apologies, Your Honors, I should have started this as sort of a housekeeping matter. I submitted a supplemental appendix because Volume 3, which is the department's record and the decision, at least the version that I had some technical issues. There was formatting, and it appeared that somehow pages were omitted, so I submitted in the event that that was the same issue for you. And so the department supplemental appendix, which was filed with our brief, contains the entirety of the department's record and the decision. And so you will, as you know, see two separate decisions.
Thank you.
I'm mindful of time, and so I would like to turn to the I would like to turn to one other issue that I think is implicit in Mr. MOUCHARITE's arguments, which is the question of whether there is other sort of non-racial harassment, and this sort of goes outside of what is addressed in my papers, but I do believe it's important to address where we're sort of focused on the conduct that he experienced over his time at State Street, which is that to the extent that there aren't sufficient facts, which we contend there are not, to support racial or otherwise unreasonable harassment, in cases that there's harassment sort of or isolation or something else that doesn't stem from a racial issue or something to that effect, under 430 CMR 4.04, disqualification of benefits, Mr. MOUCHARITE would have needed to establish that for other other harassment, that he or she took reasonable steps to preserve his or her employment, including notifying his employer unless under the circumstances the efforts would be futile or result in retaliation. So under each of the bases that Mr. MOUCHARITE claims that he remains entitled to unemployment benefits, he would have needed to establish that he took some steps or efforts to preserve his employment before tendering his resignation, or that he could not have done so. If there are no other questions, I'm happy to rest on my papers.
Seeing none, thank you both. The case is submitted.
Thank you.
Thank you. So there's no rebuttal here. So if you have anything else you want to let us know, you can submit it. You can send us in writing. Okay.
I just have one question.
Okay, one question.
Yeah, you asked a question about what's reasonable. This is the Introductory handbook that.
Okay. So why don't you put that write a letter to the court and include that in the letter, so we can look at it. Okay. Thank you.
Make sure the Commonwealth gets it as well.
Thank you, Your Honor.
Okay, we have one more case in the courtroom today, which is Cobbler versus Commonwealth, 23P1276. You just get on the right page here. All right.
Good morning, Your Honors. Michael Tomposki for the plaintiff, Kathy Cobbler, who is in the back of the audience. The plaintiff in this case was injured on a DCR-owned overpass, which allowed her to safely cross Soldiers Field Road and descend onto the sidewalk adjacent to Soldiers Field Road outside of the Charles River Reservation recreational area.
What evidence was there before the Superior Court judge about where the boundary of the Charles River Reservation is?
So there were no plot plans or deeds presented that clearly delineated the boundary. The evidence of the boundary that we contend suggested what the boundary was presented by the plaintiff, which showed a very clear fence line separating the recreational area from the sidewalk.
So the fence separates like a splash park and playground from Soldiers Field Road, right?
Correct.
Was there any evidence about whether the fence continues running in either direction along the I'm not going to say the boundary, but distinguishing between a play area or recreational area and the roadway?
The evidence that was submitted was of the area where the overpass descended onto the sidewalk, which showed a fence line in either direction separating the recreational area from Soldiers Field Road. How many feet in each direction we showed, I cannot have that information at the top of my mind, but we didn't run the whole length of the recreational area to see where the fence line ended.
The pictures show,
Sorry, just one follow-up. So that the inference that you wanted the trial judge to draw was that the fencing, the purpose of the fencing was to demarcate the edge, I guess I should say, of the recreation area.
Our position was that they had failed to show that the overpass was attached to the recreational area based on undisputed evidence, and that was their burden, and that the photographs, to the extent they had demonstrated any suggestion of attachment, were enough to raise a triable issue as to whether, in fact, the bridge was attached to the property. So again, they had the burden on summary judgment to show, as a matter of law, that the bridge, the overpass, was attached to the recreational area. We submit that the only real documentary evidence the photographs suggest that it wasn't, certainly at least enough to get to the jury on that point. So because evidence of attachment was alleged in a conclusory fashion in an affidavit without any support for why the claim was made, we contend that summary judgment.
Can I ask about the affidavit?
Yes.
So at the Superior Court during argument, you did not move to strike or object at that point, right, to the affidavit being considered?
We argued. We didn't move to strike because there's nothing wrong with the affidavit per se. It just didn't carry the day. So we did argue to the judge, and this is on page 10 and 11 of the Rule 56 transcript, that the one claim in the affidavit about the overpass being attached to the recreational area was insufficient on its face to warrant summary judgment. There was no explanation as to how the individual came to be aware of this information, what documents, if any, he was relying upon to reach this conclusion. It's conclusory. So that certainly was an argument that we made. We didn't make a technical motion to strike because the affidavit on its face, there was nothing wrong with it per se. It's just the information contained about this critical point was conclusory, and we certainly did raise that argument before the trial judge, Your Honor. And in fact, that was the only.
I'm sorry. Just what are you proceeding? Their defense is the recreational use statute. Are you proceeding on the road defect statute? Is that like what is your theory of liability?
So. There was a motion to dismiss that was filed by the Commonwealth where they raised both the recreational use statute as a defense and said we failed to comply with the road defect statute. So both of those are sort of contrary positions because they say on the one hand,
right. But what are you proceeding under?
That this is
is it a negligence case, a tort claim case?
A negligence case, Your Honor, absolutely.
And
yes.
is it under the Mass Tort Claims Act? Is it under
Correct. Mass Tort Claims Act?
Okay.
Yes.
And if we think the state of the evidence is that that strip outside the fence is part of the reservation, you lose?
If the overpass is part
it's
of
attached, it's...
You lose. Sure.
Okay.
Absolutely.
It's okay.
What if it was a sidewalk? This was really a question for him, but I'm going to try it on you. So let's assume, completely counter to reality, that it were safe to have a crosswalk across Soldiers Field Road, and that instead of having an overpass, the Commonwealth had provided access to the reservation by having a crosswalk with, signals, pedestrian signals. Would that be attached to the reservation? Let's assume, I know you don't concede this, assume for the sake of argument the reservation goes right up to the edge of the road.
Case law is very clear that streets are their own universe and that sidewalks are part of the street. So the answer to that question is no. If the plaintiff had tripped in an at-grade crosswalk, there could be no contention that that was part of the recreational area. There may be other claims based on a road defect statute if she tripped in the road that they could raise as a defense to negligence, but they could not claim that Soldiers Field Road was part of the recreational area. And that's why we contend that they can also not claim that the sidewalk that runs along Soldiers Field Road is part of the recreational area. There's case law dating back centuries, which venerable case law, maybe there's no horse involved, but it's venerable nonetheless, that says that sidewalks are part of the street that they run along. And we cite a case involving, in fact, just down the street here,
Street.
the Boston Common.
I mean, that, first of all, I may have missed it because I do, but none of that case law involved the recreational use statute, correct? Because that's new.
Oh, it didn't.
Ish.
No.
I mean, and doesn't it also depend a little bit on what you mean by sidewalk? I mean, what if instead we called this thing along Soldiers Field Road a path, a paved path?
Well, I mean, I don't think you could call it that legitimately based on looking at the photo. It's by its sort of plain nature, quite obviously a sidewalk. It's not enclosed within the recreational area. It doesn't connect, for example, for example, in the Valinsky case, you had a fully enclosed library property which had a parking lot, a manicured pathway, and then the library door, all within the off-street within the library property. This is an on-street walkway, which by any plain definition is a sidewalk, even if they want to call it a path, it's a sidewalk.
I think I just made up the path thing. I'm not
Fair
sure
enough,
that's
Your Honor.
their fault.
And I would say that, yes, none of those cases, those old cases, cite the recreational use statute, to be sure, nor has the Commonwealth pointed to any case in which a sidewalk was held to be part of the recreational area. Now, they say conclusively in their brief that cases have routinely included sidewalks, but none of the actual cases that they cite have anything to do with sidewalks. Syke v. Canton, the issue there was about whether charging tickets to the basketball game took this out of the realm of the recreational use statute. Dunn was about steps leading up to City Hall. Garante was about falling from bleachers. Constantine v. City of Cambridge was a parking lot, and again, Valinsky, as I said, was a fully contained off-street area of a town library. So in no case has anyone ever contended that a sidewalk was part of a recreational area.
Well, but I mean, that doesn't mean it couldn't be, right? Let's assume an alternate universe where the Commonwealth actually paid a survey or pulled something from the map room, and they had a plot that showed that the reservation ended at the edge of I don't think there is a breakdown lane there, right? But at the edge of
the road,
Soldier Field Road. I don't think you would be arguing, but tell me if I'm wrong, that paving a portion of the reservation turned it into a sidewalk and took it out of the reservation.
If they had produced a deed or a plot plan that showed that the reservation encompassed, yes, the walkway, even though it was outside the fence, we probably would not be here, but they didn't.
But just to follow up on that point, so does your argument rise and fall on the fact that it is in fact a sidewalk that it empties into and connects to? And maybe this is what Judge Hershfang was getting at, if it was just not even a pave, like a dirt path, or nothing.
It's hard to answer that question, Your Honor, but I will try. Our contention is based on the evidence that was presented to the trial court, that the overpass very clearly dumps out onto a sidewalk.
Right.
And so whether in another configuration, if you think of other areas of the Charles River where the overpass dumps into clearly a pedestrian area,
Right.
not a sidewalk,
Like
but
the
into the
Fiedler
park,
overpass,
like
for
by
example.
the hatch shell, for
Yeah.
example, very clearly then the overpass there is attached to the recreational area, whereas here it does appear on its face, in the absence of a plot plan or a deed showing otherwise, to be separate, in that it dumps out into a sidewalk of a thoroughfare, of a boulevard, whatever you want to call it, and that cases for dating back decades, if not centuries, have said, and I think it's fair to say, in the absence of contrary evidence, the sidewalk is part of the street, and it's not part of a park that it may also be adjacent to. And in the absence of evidence that it was attached, a conclusory affidavit from a DCR employee saying, oh, by the way, it's attached. I mean, the statute says the word attached, and one of the employees wrote in the affidavit, it's attached, without any explanation as to how he knows this.
Right, so you're saying there's a disputed issue of material fact, and
There's a
this thing
dispute.
needs to go back.
At a minimum, there's a dispute. If anything, I would say there's more evidence that they were separate. But at the minimum, there's a dispute as to whether the overpass is attached to the Charles River recreational area or is attached to Soldiers Field Road, based on, again, the visual evidence. Also point out, and in addition to the case law that holds that sidewalks are part of the road, DCR's own regulations, which were in effect until 2022, define sidewalks as part of the roadway that they run along, which they've now disclaimed those regulations as part of this litigation and said, oh, that only relates to parking and nothing else. But nevertheless, that's their own regulation. I would also say that if this court were without conclusive evidence to hold that the sidewalk is part of the park and not the road, that you would be creating issues in future road defect litigation, because historically, injuries that occur on sidewalks, cities and towns have very limited liability. There's a strict notice requirement, a statutory cap on damages, on the assumption that if there's a defect in the sidewalk, it's sometimes hard for the towns to fix this in a prompt fashion. We're not going to bankrupt the town over a defect in a sidewalk. And if this court were to rule that sidewalks can be part of parks, even if they run along streets, or other private property, for example, then I think we're creating problems in this other arena that the court may want to be very careful to avoid.
But I mean, so let's talk a little bit more about the Esplanade, because it's nice to think about that on a freezing cold, snowy day. So the Esplanade has a lot of, I'm going to call them paved ways,
Yes.
right? There is a paved way that runs actually pretty proximate to the river itself that goes, I think, the whole length of the Esplanade. You're not arguing that that is a sidewalk within the meaning of the law that you are, the adjacent to the roadway sidewalk?
No, a sidewalk would be a path that is directly adjacent to a thoroughfare of some sort and made for the purpose of walking along the thoroughfare. Not a paved path in a park would not count, no, Your Honor.
Does anybody want to walk along next to Soldiers Field Road?
Does anyone want to?
Yeah, seems so unpleasant.
Well, I don't know the answer to that, but in this case, you
the
had to.
next question you might have an answer to. The evidence is pretty clear that your client was involved in a recreational activity, but maybe she's leaving it. So how does that fit in with the analysis?
I would say it doesn't, because there's no dispute that she was walking when this injury occurred. The question is whether she was on land that she was able to access because she was engaging in a recreational activity. And our position is that walking on a road or on a sidewalk, you're not there. You don't have permission to be there because it's a recreational area. You have permission to be there because it's a public street. And so if you're in the recreational area, the Charles River Reservation, you're there. Your permission is contingent on you being engaged in a recreational activity, but crossing the street is not a recreational activity.
The accident occurred on the Telford Road side of the?
No, it occurred as she descended on.
It occurred on the Charles side. On the reservation
leaving,
side.
right?
She's leaving as she descended back on the Telford Road side.
So it's more like on the far side of
On the far side, away from the reservation, yes. So if there are no further questions, I would ask the court reverse the grant of summary judgment and remand the matter for further proceedings.
Thank you. We'll hear from the Commonwealth.
Good morning, Your Honors, and may it please the Court, Michael Shiposh on behalf of the Commonwealth. To start off where we just pick up where we just left off here, the Superior Court correctly allowed summary judgment because Ms. Cobbler's one-count complaint for negligence is barred by the recreational use statute, the purpose of which is to encourage public and private landowners to open up their property free of charge for recreational pursuits. And in order to encourage that purpose, one thing that the legislature did was provide immunity for negligence and gross negligence for injuries that occur unless there is wanton, willful, or reckless conduct. And so this case fits squarely within that statutory purpose. The text of that statute also provides that the coverage includes the land and structures attached to it. And for purposes of this case, this is not something that needs to be far-reaching about all these other sidewalks across boulevards and across other areas. This is about the Gleason Overpass, which attaches to the Charles River Reservation. Just like other structures that have been held by this court in prior cases to be subject to the recreational use statute. Those structures include stairways, bleachers, sidewalks and walkways.
But in any of those cases, it says an interest in land, including the structures, buildings, and equipment attached to the land, which in real estate terms, that would be like the house on top of it. Are there any case where the structure is something that goes way over here? It's not over, right? Most of this bridge is not over the park, it's over Soldiers Field Road.
So you're right, Your Honor, and there's not an enormous number of cases that involve this statute, but the cases that we do find don't have this exact kind of situation. However, another part of the summary judgment record is the order of taking and taking plan, which confirms that DCR also owns and maintains, and it says Charles River Reservation on both of those documents, the Telford side, the landing area of the overpass as well. And so while there isn't an exact case that is exactly like this, there are cases where structures and walkways and sidewalks and buildings have been covered.
I mean, but in this case, I mean, the Soldiers Field Road is part of like originally MDC property, right? It's patrolled by the state police, and it used to be, so.
Correct, it's a parkway.
Like DCR has jurisdiction over both the road and the park next to it.
That's correct, Your Honor, it's a parkway, it is. And to address Justice Hershfang's question earlier about whether if there were at-grade crosswalks there, might the situation be different? I think that would be a different situation. We're talking about a structure that's attached to the Charles River Reservation here, and there are no other opportunities for pedestrians to access the reservation on foot crossing Soldiers Field Road unless they use an overpass such as this. There is a parking lot. Yes, Your Honor.
But essentially, isn't this just an overhead, a raised
Crosswalk in the sky. Yeah.
Right? Someone decided, probably rightly, smartly, we're not going to hold up traffic on a very busy roadway, right? So we're going to make it easier for everyone to just bypass that, and so traffic's not affected.
So traffic isn't affected, and it's an overpass that allows people, and the only reason that you're traveling across that overpass is because the Charles River Reservation is on the other side of it. There's no other property. There are other cases, involving walkways where they go to different areas, and those might be different. But here, the purpose of this overpass is to access reservation land. There's no other land that's on the other side of it. You're hitting reservation and then you're hitting water.
But that's not, still going? That's not dispositive under the statute, right? Because if what the evidence showed was that there is this walkway and then there was, I don't know, like a Starbucks that was on privately owned land, and then there was a reservation, you couldn't, I don't think, argue that the walkway was attached to the reservation. So even though nobody's actually going to take a walkway to go to a Starbucks when you can do that on the other side much more easily, and you could still argue the only reason to take the walkway is to go to the reservation, the failure of an attachment would be fatal to the Commonwealth's defense.
I think in a case where there was other things going on there, other areas, in other words, if this was no different from a overpass that was crossing over, for example, T-tracks, and you're, to a neighborhood and that was separated by some connection to the trains, that might be a different situation, but that's not the situation that we have here. What we have here, the only property that's north of it is Charles River Reservation, and that extends for 20 miles. And to another issue that arose earlier in the arguments here is that the only evidence put forward by the plaintiff in this case was to show a portion of a fence. There is no allegation or factual averment in the record that fence extends all the way down, nor could one be made in good faith, because it doesn't. That fence is a limited fence, and as Your Honor pointed out, the opposite side of that, there's a picnic area. You can see the picnic tables in the record. There's a splash pad. There's a playground, and there is no evidence at all, one way or the other, about what the significance of that fence is. There is
so don't we have to then draw the inferences in favor of the non-moving party?
Well, yes, Your Honor, but this is in this situation, we have evidence in the record that was not stricken, that was in for its full value, that says this structure is attached to the Charles River Reservation. The existence of a fence does not mean, and it's not a reasonable assumption to say that is a property demarcation. But homeowners have, with pools all the time, put fences up, but they're not saying this is where my property ends. They're saying, I want to make sure that no children have an accident in the pool, or no animals come and have an accident.
Because it's an attractive nuisance. So, as I look at the affidavit, it seems to me there are two statements in it that are helpful to you and that the judge based the ruling on, right? First, there's this section of the reservation is bordered by Soldiers Field Road. That's in paragraph 4. And then in paragraph 6, which I think is obviously the thing we've been talking more about, the north side of the Gleason overpass is physically attached to the Charles River Reservation and connects blah, blah, blah. So I guess the person who did this is a director of transportation, division of design and engineering, presumably an engineer, a design traffic engineer of some sort. If we don't, I'm going to try to say this in a comprehensible way. I apologize because I'll probably fail. If I read the north side of the Gleason overpass is physically attached to the Charles River Reservation as a statement of observation or engineering and not a legal conclusion, because this person is not a lawyer, right? Does that get you where you need to go? Because attached is actually a legal conclusion in the statute, right? I don't know what it means. I'm not sure any court has told us what it means. But isn't there some slippage?
So you're correct that Mr. Santos is not an attorney and isn't offering a legal conclusion here. But as you pointed out, through his role as Director of Transportation in the Department of Conservation and Recreation's Division of Design and Engineering, he is knowledgeable about these issues, about what the structure, and this is reservation property, the overpass and the land that was taken on the other side of the overpass is all owned by the Department of Conservation and Recreation and maintained by it. And through his job responsibilities, he's positioned to say this is attached to the Charles River Reservation.
Right, and he has said that, right? And I guess my point is not, is he qualified or is this, some kind of Daubert-Lanigan issue? Crediting that he can say it's physically attached. Does that compel a legal conclusion that it is attached within the meaning of the statute?
On this factual record, Your Honor, it does. And the reason is because, as we just heard before, there was no motion to strike this, and in some sense it was said, this is a perfectly fine affidavit, but we were just arguing about its weight. Well, once that evidence is accepted, it's incumbent upon the non-moving party to present other evidence, whether by affidavit or other competent evidence, in order to demonstrate the existence of a factual dispute that merits a trial by jury. And in this case, that did not happen. The only information that came forward in response to this were the Google images, which do not say one way or the other a single thing about the ownership of the land at the footing of the Gleason overpass whatsoever that contradicts the affidavit that was, and the rest of the summary judgment record that was put forward. And so in light of that record, the Superior Court correctly concluded that summary judgment was appropriate here, where the recreational use statute applies to the land and the structures, like the Gleason overpass, attached to it. Turning briefly to the question of distinguishing legally between sidewalk and walkway or otherwise, there are plenty of walkways and sidewalks throughout the 20 miles of the Charles River Reservation, many of which are visible on the overhead Google images that are part of the record. This walkway is no different from the ones that are along the water or that cut through the various playgrounds and other structures. There's no distinguishing features or differentiation between them in the record that would allow for a different conclusion to be made.
So the path sidewalk thing, assume that there was that on other parts of Soldiers Field Road, there was something that looked just like a sidewalk right next to the gutter there. You would say that's a path that's for recreational use, not a sidewalk.
I'm not sure I followed the question, Your Honor. It was on the opposite, on the south side?
No, on the same side.
Same side.
Suppose what we don't see in the picture, if you go down, there's then across that driveway there's a sidewalk, no fences, and they would say that sidewalk is not part of the street; it's part of the reservation.
The property, yes. I would say that that's correct. And again, there are times, and again, this isn't part of the summary judgment record, but there are times where there's the Arsenal Bridge, where if you continue on Soldiers Field Road, everything spills into that walkway. And in order to continue on to the remainder of the Charles River Reservation, you have to use that. And so again, that's not part of the summary judgment record, but the question came up earlier about do people use that area, that walkway, sidewalk for recreation? The answer is unequivocally yes. However, not in our summary judgment record, and what was in the record was that area is included in reservation land. The parking regulations that concern sidewalks, there's already appellate precedent indicating that those regulations cannot be used to define, this is the Kemble case, Your Honor, that I'm referencing that's cited in the briefs. Those definitions of sidewalk cannot be used to define another statute. In the Kemble case, it was the road defect statute. In this case, it can't be used to define the recreation use statute. And finally, the sidewalks, the other sidewalks that were cited in cases cited by Ms. Cobbler, those are not, none of those cases deal with the recreational use statute. And while a sidewalk in a regular city block might be subject to other statutory provisions, this one is different because it's part of the Charles River Reservation. And so as a result of that, based on the summary judgment record, the recreational use statute applies, and consistent with its purpose to encourage the opening up of property and the recreational pursuit and use of that property free of charge. As a consequence of that, the statute applies, and negligence and gross negligence claims are barred as a matter of law.
You said one of you said it's 20 miles. Does the reservation extend the whole length of the Charles from Boston up to Newton or whatever?
It does. It's 20. It's an agreed upon fact that the Charles River Reservation is a 20-mile tract of property that extends along the Charles. What town that exactly ends in, I'd have to look more closely. But yes,
it's very windy.
It does. Yes, Your Honor.
Questions?
I think it's Waltham, but I'm not sure.
I think that's right, actually, Your Honor. Let me say it. So, unless there are further questions from Your Honors,
okay.
rest of the papers and ask for affirm.
Thank you both. This is really, I mean, kind of an interesting little case. It is submitted. So that will conclude what we're doing in the courtroom today. I want to thank the court officers and the clerk and the other clerks for your help, and thank the lawyers. And we will be taking a recess here, but we'll be reconvening on Zoom for the DCF case in just a few minutes.